Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Thank you for joining us for this podcast, which is part of our series looking at trends in international arbitration with a focus on different regions. In this podcast, we'll be looking at international arbitration in and involving parties from across the Baltic States, with particular focus on Lithuania. I'm Ian Meredith, a partner in K&L Gates London office and a leader in our firm's international arbitration practice group, and I'm delighted to be joined today by three leading arbitration practitioners from Ellex Valiunas, a top-ranked pan-Baltic law firm. Firstly, Vilija Vaitkute Pavan, who is a leading disputes partner at Ellex. She frequently acts as both arbitrator and counsel. Vilija has served as an ICC arbitration court member for Lithuania, and she's also, interestingly, the honorary consul of the Grand Duchy of Luxembourg in Lithuania. I'm also joined by Tadas Varapnickas, who is an associate partner at Ellex. He is ranked by Legal 500 in the arbitration power list for Central and Eastern Europe. He's also a lecturer at the Vilnius University Faculty of Law and author of various scientific publications and editor of the only arbitration-related journal in Lithuania, Arbitration Law and Practice. And finally, I'm joined by Simona Budreikaitė. Simona is also an associate partner at Ellex Valiunas, and she has an extensive experience in both commercial and investment arbitration. Before we get started, I'd just like to note that this podcast series is limited in scope as appropriate for a general audience and the applicable time constraints. The information in this podcast series is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case, and all speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP, Ellex Valiunas, or any other entity or individual. Well, thank you very much for agreeing to participate in this podcast. Many of our listeners may not have had the opportunity to work with counterparties from the Baltic States. If I could start with you, Vilija, in general terms, could you share some insights into the types of disputes having an international element that are dominating or anticipated to dominate in the Baltic region over the coming period?
Thank you, Ian. The type of disputes in the Baltic region is in fact influenced by the appropriate stage of economy, and it depends very much on the trends of economy. For example, at the moment we have a very huge increase of big infrastructure projects in our part of the world, meaning from wind park, offshore wind park, LNG terminal. We have also Rail Baltica project that is going to connect Poland, Latvia, Lithuania, Estonia by railway. So those big infrastructure projects, they definitely involve construction disputes, supply disputes, insurance disputes. Also, the war in Ukraine had impact the sanction-related disputes, meaning that Lithuania, Latvia, Estonia, as well as other European countries, they have to implement sanctions. And there are lots of disputes and anticipated even to grow even more related to the sanction implementation dispute, to the sanction implementation. Then the supply, the growing economy in our part of the world, and just giving you as one number, statistical number, in comparison, Lithuania I'm talking, in comparison of Lithuanian GDP, first quarter of 2024 to comparison first quarter 2023 was grown by 2.9%. When economy grows, one of the engines for growing economy in Lithuania is increased exports. Increased export encompasses more sale and purchase disputes, the supply disputes, insurance disputes, also there in connection to infrastructure, as well as might be in some certain type of supply, also transportation of high value cargoes by roads. And we anticipate even more probably the growth of M&A disputes. Maybe in Estonia is anticipated the bankruptcy and restructuring disputes. But where international element concerns, then definitely construction, supply, insurance disputes are going to grow as we anticipate.
Thank you very much. Tadas, I appreciate we're talking in general terms here and everything is contract specific. But in general terms, when drafting contracts for cross-border contracts, what tend to be the seats, the arbitral rules and foreign laws that parties are most favourable towards?
Thank you for this question. Indeed, most arbitration proceedings in the region are administered, and as a rule, ad hoc proceedings are very exceptional and rarely met in the Baltic-related contracts. As regards the choice of arbitral institutions, some of the most popular choices include actually local institutions, such as the Vilnius Court of Commercial Arbitration. Local institutions are normally chosen for small or mid-scale disputes. However, at least the Vilnius Court of Commercial Arbitration, I would say, found its place in the arbitration community as a trustworthy institution with a good reputation, which is chosen for bigger disputes too. As regards large-scale disputes and international well-known arbitral institutions, from our experience, SCC and ICC are the most popular choices, and other institutions are actually far behind. For instance, the popularity of the London Court of International Arbitration has shrunken in the recent years, of course, because of Brexit-related reasons. Other institutions, such as, for example, VIAC in Vienna or FAI in Finland, they can also be met, although not very often, I would say. Now, the choice of the seat, the second part of your question, I believe is influenced very much by the choice of arbitral institution. For example, it's quite usual to see an SCC arbitration with a seat in Stockholm or ICC arbitration with a seat in Paris, although Vilnius for Lithuania-related arbitrations or Tallinn for Estonia, Riga for Latvia, they are also popular choices, particularly when contracts are concluded via public procurement proceeding. Now, you also asked about the applicability of foreign law, if I'm not mistaken. So, since the Baltic entities are frequently involved in cross-border transactions, it is not uncommon to see contracts to be governed by foreign law, and the reasons behind foreign law are probably the same as in any other region. On the one hand, because of the international character of the transaction, the parties agree to apply a law that is foreign to any of the parties to the contract, and on the other hand, because of the market limitations, there is still a perception that in case of a dispute, it would be more convenient to have foreign laws as applicable, since it may be easier to select international arbitrators or find legal experts, for example. As regard the most popular choices, I mentioned that the popularity of the LCA had shrunken, but this is not the same for the applicability of English law. Despite Brexit, this remains the most popular choice, especially in the classical business sectors such as insurance, aviation, shipping, financing. In all those sectors, English law apparently was not influenced by Brexit and remains the leader in the field. Other choices, I would say, mostly depend on the nationality of the parties themselves. For instance, we can find Swiss or German law or Swedish law, particularly in the contracts involving Scandinavian entities. And finally, also the choice of local law, such as Lithuanian law, is also noticeable, especially in public tender contracts where public entities prefer to have the local law to be the governing law of the contract.
Thank you very much. So, Simona, if I could ask you about the attitude of the local courts. I think Tadas has helpfully indicated that there is a place for seats within the Baltic States, so that therefore triggers the relevance of the supervising courts in the Baltic States. Could you perhaps give us a little overview of the attitude and approach in terms of whether they're pro-arbitration, particular issues or challenges that people maybe ought to be aware of?
Yeah, sure. So as a general rule, I would say that the courts in all three Baltic states are indeed pro-arbitration. And this is considering that the arbitration laws in both Estonia and Lithuania now for many years are based on the ancestral model law. While when talking about Latvia, Latvia's lawmaker has just this year reformed the Latvia's arbitration law so that it also corresponds to the ancestral model law. And I think that the influence of the model law itself is also one of the key reasons why the local judges, when, for example, interpreting arbitrated-related provisions in satellite court disputes, frequently rely both on the international practices and also on the international doctrine. So, for instance, there are many examples of arbitration-related court rulings where, for example, the international doctrine is quoted on, for example, extension of the arbitration clause to non-signatories and so on. And while this is not so evident with respect to, for example, other areas of law, when we're talking about arbitration and reliance on the international practice, I think that it shows that in this field, the Baltic courts really try to be international. Talking about that approach. And also the statistics is also a very good indicator, because when we are talking about, for example, recognition and enforcement proceedings here in Lithuania, only in very rare and very extreme circumstances, the local courts really refuse to recognize arbitral awards or set them aside. So, for instance, while the most commonly invoked ground by the parties, I think not only in the Baltic states, but also worldwide, is the public policy exception. When the courts are dealing with this exception of the New York Convention, it is perceived very narrowly, and the courts see it as encompassing only the fundamental legal norms and the legal norms of international nature, rather than just any mandatory local law provision, be it Lithuanian or for example, Estonian law provision. So this is with regards to recognition and enforcement, but also in other areas, we also see the tendency that courts are pro-arbitration. And for instance, talking about Lithuanian recent practice, most recently, Lithuanian Supreme Court in a couple of cases found that an arbitration clause included, for example, into the articles of association of various organizations, for example, of a sport organization, is valid and enforceable to all members of that organization. And in another very recent case, also the Lithuanian Supreme Court recognized, for example, an arbitration clause which was included in a carriage contract governed to the CMR Convention as also valid and enforceable, even though the arbitration clause in question did not explicitly refer to the CMR Convention and therefore did not exactly meet the requirements of Article 33 of that convention itself. And what such practice shows is that the local courts are really keen to enforce arbitration agreements and are quite flexible when interpreting them, so to speak, are trying to go beyond the very formalistic approach.
Thank you very much. Well, I think that concludes our initial podcast looking at the general position in relation to arbitration across the Baltic states. Please join us in our second follow-on podcast when we're going to be looking at some more topical and some investment-related issues. Thank you very much.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.